Good morning, everyone. You're all very welcome joining us this morning, in this cold morning. I'm very pleased to welcome you all along, but particularly pleased to welcome Jenny Rankin and Rachel Richardson from DWF Law, who'll be taking us through our seminar this morning, which is on workforce evolution, managing change in a challenging economy. As we were speaking with Rachel and Jenny, and they were asking about the kind of issues that manufacturers were facing at the moment. Obviously, given the challenges of the domestic and the global economy, given challenges across the globe in terms of the cost of doing business, additional taxation, wars impacting on trade markets. We know that many manufacturers are trying to make sure that they keep themselves right in the employment space. They try to make sure that whenever they're planning their workforce that's right-sized for their business, that they look after the people that are employed there, and they also look after the company, ensuring that it's legal. So we've asked Rachel and Jenny to join us this morning, just firstly as an update about the responsibilities that employers have in and around this employment space, and to give you some insight into what that kind of best practice would be in order to ensure that your business is operating legally and in the interests of not just the directors, but the people involved in the business as well. I'm going to hand over to Rachel in a second, but just to say we are recording the session. We will be sharing both the slides and the recording after the event. We hope, whilst it's online, we hope that you're able to participate in it. So we do have both a Q&A function and a chat function. So if there are questions that you'd like to ask, then please either pop those into the Q&A preferably or into the chat function, and we'll make sure that we can address those questions for you. Today's not about getting free legal advice. Obviously, DWF are incredibly skilled. They're incredibly knowledgeable about the employment market here in Northern Ireland, but they also have a global footprint as well. So if there are very specific questions to your business, I know that Jenny and Rachel will be very happy to engage with you after the seminar today. But if there are general questions, if there are things that you think would be useful to have clarity for yourself and for other people who are watching in, then do drop those questions into the Q&A and into the chat function. We'll be back after the slides and presentations with that Q&A. So hopefully you'll enjoy the session. We expect to be here for about 55 minutes or so. So please do make the most of the opportunity that we have with the expertise that we have with us this morning. Rachel, I'll hand over to yourself to kick off on behalf of colleagues.
Thank you, Stephen, for that very kind introduction and for giving us the chance to speak to your members. We really appreciate it and welcome everybody to today's webinar on managing change in a challenging economy. Before we get into the slides, I wanted to give a brief background, very brief, on who we are and what we do at DWF. DWF is a leading global law firm with multiple offices across the world. We have a large employment and pensions team who work globally and act for a broad range of clients, from local SMEs to multinational conglomerates. We also advise human resources teams, in-house lawyers, and provide support directly to businesses. We'll support the business at every stage of the employment journey, from recruitment to termination and everywhere in between. And we advise businesses on a wide range of employment issues, going from things like employee relations issues like redundancy, which we're talking about today, through to defending claims in the tribunals and more. So I'm leading the employment team here in Northern Ireland. We also have a substantial team of employment lawyers in GB and colleagues in ROI. So we can advise across the whole of the UK and ROI, and our local approach always ensures we're familiar with the idiosyncrasies of each local jurisdiction. So that's that piece on who we are. In terms of the agenda, if you just go to the next slide, please. So what's on the agenda today? I'm shortly going to be handing over to my colleague Jenny. And Jenny is going to be talking about how to identify a redundancy situation and the redundancy process and key considerations an employer needs to take into account. I'm then going to pick it back up from there. I'm going to look at consultation, alternative employment and trial periods, appeals and redundancy pay, and then asking briefly, like, if that doesn't work, and what if an employer gets it wrong? I'll then touch very briefly on short-time working and layoffs, and we're then going to finish by dealing with any questions that come in. As Stephen has mentioned, please do put those into the chat function or Q&A, and we'll look at those at the end. So I'm now going to hand over to Jenny, who is going to look at the very first and arguably the most important question here, which is how do you identify a redundancy situation? So Jenny, over to you.
Thank you, Rachel. So yes, I'm now going to discuss some of the legalities around redundancies, including how to identify a redundancy situation. I'm going to walk you through a step-by-step guide to the redundancy process and some key considerations for employers. So firstly, let's consider how to identify a genuine redundancy situation. So redundancies typically happen when an employer needs to reduce the workforce, and this may be because a particular type of work is no longer required, or fewer employees are needed for a specific kind of work. It is not a genuine redundancy if the employer immediately takes on a direct replacement. Sometimes redundancies become necessary due to changes in markets that organisations must react to in order to stay in business and remain competitive. Redundancies may be necessary because a workplace is closing down altogether. A redundancy that is not genuine would not be considered an unfair dismissal, and therefore it's imperative to ensure that any redundancy process is not construed as a sham. So, to be defined as a genuine redundancy situation, an employer must consider whether their situation falls within the following scenarios. So firstly, is there to be a workplace closure? Secondly, will there be a relocation of the business? Or thirdly, is there to be a reduced requirement for employees to carry out work of a particular kind? For example, if there's no longer a business need or new processes have been introduced. Next slide, please. So if you're satisfied that your situation meets the definition of a genuine redundancy and you've decided that it is necessary for your business to consider making redundancies, you will need to ensure that you follow the correct process to best protect your business from potential litigation. So we've compiled a helpful guide that I'm going to take you through now. So we've split the process into 4 segments. The first deals with the initial steps, which should be taken by an employer embarking upon a redundancy exercise. These are the steps which should be taken prior to any employee consultation. So firstly, employers should consider and put into writing the business case for proposed redundancies. It is important to reflect upon whether this is a necessity and consider any potential alternatives, such as restructuring, and redundancy really should be a last resort. Next, you must consider the selection pool and selection criteria, and I'm going to go into this in more detail later on, but just want to flag that it is very important that this is carried out in the correct manner to avoid any claims of unfair redundancy selection. You should also consider at this point whether there is a collective redundancy, and if so, it's important to submit a form HR1 to the Department for the Economy for Northern Ireland. And Rachel is going to talk about this process in more detail later on, but I just wanted to flag that it's a consideration at this stage. So once these steps have been carried out, an initial meeting with affected employees should be held, and this is to inform them they're at risk of redundancy and the reasons why. For example, if their business is closing or if there is a reduced requirement for employees. They should be notified of the selection pool, which is maybe a team or all employees at a particular factory or site, and they should be made aware of the selection criteria that's going to be utilised. So, following this meeting, correspondence should be issued to all employees who were invited to the meeting, including those who were not in attendance, to confirm the details of the meeting and what was discussed. So next slide, please. At least 2 managers should apply the predetermined objective selection criteria by using a scoring system to identify the employees who are at risk of redundancy. And once this process has been completed, a second letter should be issued to employees who have been provisionally selected, inviting them to a meeting to discuss their provisional selection and summarise what consultation has taken place so far. Next slide, please. So following the second written correspondence, a first consultation meeting should be held with each employee who is at risk of redundancy. The employer should give the employee adequate time and information to prepare properly for all consultation meetings. There is no obligation to allow an employee to be accompanied to consultation meetings. However, the employer may choose to give the employee that option. The purpose of the first consultation is to discuss each individual's scores, consider any comments they may have upon their scores, and to discuss alternative positions in the business or any other alternatives to redundancy. Employers do have a duty to look for suitable alternative employment within the business that they should offer to employees who are at risk of redundancy. Rachel's going to discuss alternative employment in further detail later on. The employer should consider any comments made on scoring and follow up where necessary. And furthermore, the employer should follow up on any suggestion for alternative employment or other solutions to redundancy made by the employee during the first consultation. It's important to remember that this process is a two-way street and employee comments should be given due consideration. Next slide, please. Thank you. So it should be considered then whether further consultation is necessary. If there are any further solutions suggested by the employee, they should be explored and there should be a further follow-up process and further consultation should be arranged. So there's no prescribed limit of how many consultation meetings should be held. There should just be as many meetings as necessary to ensure that all alternatives are explored, as redundancy should really be the last option. So if no further consultation is necessary, a final consultation meeting should be held with each relevant employee to confirm that they have been selected for redundancy. And this is to confirm that they are being dismissed and to give the individual details of their redundancy package. So as I'm sure you know, in Northern Ireland, the three-step statutory dismissal and disciplinary procedure is still in place, and therefore it's imperative that any invite to a final consultation meeting, if the employee has the length of service requirements and they're being dismissed due to redundancy, this letter should note that there is a possibility of dismissal following the meeting to ensure compliance with the three-step procedure. So following the final meeting, written correspondence should be issued to the relevant employees to confirm that they're being dismissed due to redundancy. And this letter should set out the employee's redundancy calculation, and this should include their statutory entitlement and any enhanced entitlement up over and above the statutory entitlement. Importantly, the letter should include the right to appeal the decision to dismiss the employee. Any subsequent appeal should be heard by an independent individual within your business who is preferably more senior to whoever carried out the redundancy process. And Rachel, again, will go into appeals in a bit more detail later on in the session. So that was really just a high-level overview of the redundancy process. We would always recommend that proper legal advice is sought before embarking upon a redundancy exercise. So just moving on to key considerations. So next slide, please. So you will see in this slide, there's a few key points that any employer should be well versed upon before undertaking a redundancy process. And I'm just going to talk you through each of those. So firstly, sorry, next slide, please. So firstly, you must have a good business reason for making employees redundant. You should also take steps to avoid making anyone compulsorily redundant, and all alternatives should be considered before the process commences. And there's a few ways of doing this. So for example, you could consider whether there are other ways which your business could cut its outgoings rather than a reduction in staff. So for example, considering streamlining production process or use of alternative materials. You could consider whether there's a particular area of your business where there are too many employees for the workflow, whether there are employees within this area who have transferable skills who could be redeployed to suit business needs. For example, could you find alternative employment for these employees in another area which is understaffed, or whether in an area where there are opportunities for growth? Generally, you could consider a business restructure, which involves reorganizing the business or specific roles to meet changing needs. And this could include offering employees the opportunity to work at different premises or within different teams, as discussed. But please note, it's very common for restructuring exercises to then become redundancy exercises, and we would recommend that legal advice is always sought to ensure that restructuring is administered correctly. So you could also consider, is there a way to change how your services are provided? So for example, would it be possible to consider reducing operational hours whilst maintaining the same level of output, which could potentially allow for a reduction in overtime shifts offered to employees to accommodate such a change? So please just bear in mind that if any of these changes would amount to a change of the employee's terms and conditions of employment, this would require consultation with the affected employees and their consent. We don't have time to go into this in any great detail today because it's a very large topic. However, please do bear in mind that proper legal advice should also always be sought before considering proposing any contractual changes to an employee's terms and conditions of employment. So finally, if you've come to the conclusion that redundancies are necessary, you should consider whether you wish to ask employees to put themselves forward for voluntary redundancy at the outset of the redundancy process. And Rachel will discuss that in more detail later on. Next slide, please. So if you have come to the conclusion that there is a business case for redundancy, then you must consider how to plan for redundancy selection. And this includes identifying the pool of employees who will be at risk of redundancy and deciding upon which selection criteria to apply to those who are at risk. Next slide, please. So the selection pool should include employees who are genuinely at risk of redundancy, and this could include a particular team or department, it could be a particular role or function within the business, or it could be a particular location if there's multiple factory sites or offices within your business. The employer should consider what work is disappearing and which employees are carrying out this work. If there is a clear link between the particular work stream, which is no longer required, and the employees who are carrying out that type of work, then the pool will generally be more easily identifiable. However, identifying the pool does become more complex if employees have multiple skills and do different types of work, or if they can be required to do different types of work under their contract of employment. So employees are more likely to object to being considered for redundancy in this situation, particularly if they can identify other employees within the business who are not at risk of redundancy, but with whom they share interchangeable skills. It may be unreasonable for the business to identify one employee as being in the pool just simply because they are doing a particular type of work that is disappearing, and ignore another employee who is doing different work where the first employee could have carried out that work. So if an employee can point to another employee with interchangeable skills who also has less service than them, then this may strengthen that argument that they should be included in the pool. If the work carried out by the employee and another employee who has not been included in the pool could be categorised as low skilled, the skills are more likely to be considered to be interchangeable. So it's essential that the pool is broad enough to avoid any accusations of unfairness, but also specific enough to target those roles which are genuinely redundant. It's also very important to ensure that the pool is not discriminatory in terms of age, gender, disability, race, or any other protected characteristic. And the redundancy pool should be clearly communicated to employees. Where an employer recognises a union, it will usually be expected that the employer discusses the choice of pool with the union. So another factor which may be considered by employers when defining the selection pool is bumping. Bumping in a redundancy situation refers to the practice where an employee whose role of redundancy is bumped by their employer into another employee's role. And this typically occurs if the employee whose job is redundant has the necessary skills, experience, or seniority to take on a different role within the organisation and can essentially displace another employee whose role is less secure or is also under threat. So just to give an example of how bumping works. So employee A is at risk of redundancy within a specific role. Employee B holds a similar or lower level role within the same organisation. If employee A is able to perform the job that employee B does, the employer could bump employee B, meaning employee B would be at risk of redundancy instead of employee A. Bumping is a way for employers to avoid redundancies for employees with seniority or specific skills by having them take on different positions within the company. However, it can only happen if it's part of the redundancy process, if it's agreed upon by both parties, and if it is done fairly and doesn't cause a disproportionate impact on employees. So it's very important that specific legal advice is taken before considering the use of bumping, because it is a very complex area of redundancy law. Next slide, please. So when choosing which selection criteria to use during a redundancy exercise, employers must ensure that the criteria is fair, objective, and non-discriminatory. It's important to approach this process carefully to avoid any potential legal challenges, particularly claims of unfair dismissal or discrimination. The employer must ensure that the criteria which is chosen cannot be open to interpretation or influenced by personal biases. It's important to document why specific criteria have been chosen and how they apply to your workforce. And the criteria must not discriminate against any employee based on any protected characteristic, such as age, gender, disability, race, religion, sexual orientation, religious belief, or political opinion. And to avoid any claims of discrimination, employers should review the criteria to ensure that they do not inadvertently disadvantage specific groups of employees unfairly. So the criteria should be relevant to the needs of the business, and this can include factors such as skills, qualifications, and the ability to perform in a specific role. So you will see in the slide that this is included on the list of potentially acceptable selection criteria. And just to note, when utilising skills and qualifications, employers must consider relevant training which has been undertaken by employees, relevant certifications which they may have, and any qualifications which are related to their roles. Another potentially acceptable selection criteria is attendance. And this can be very useful if excessive absenteeism is an issue, but it must be applied fairly and consistently. And any absences due to disability-related illness or pregnancy should not be taken into account, especially, because this could be leave employers vulnerable to a legal challenge. Disciplinary records and timekeeping can be acceptable selection criteria, and it is important that these records are well documented and up to date. Only live warnings should be taken into account, and that's very important. And if you're considering using timekeeping, it should be based on well documented records rather than just general observations. So moving on to last in, first out, and this is a method which does present a significant risk to employers because of its potential to indirectly discriminate against younger people or against women who tend to have shorter periods of employment due to pregnancy or maternity leave. And this could lead to a claim of indirect discrimination, which can arise when an employer implements a provision, criterion, or practice which puts certain people at a disadvantage and which cannot be shown to be a proportionate means of achieving a legitimate aim. Employers may consider using last in, first out as part of their selection criteria, as long as this is used in conjunction with other criteria, which is fair and objective. So lastly, just on the list of potentially acceptable selection criteria is performance and ability. Now, we would advise extreme caution if you decide to use performance and ability, because it can be open to interpretation and therefore not objective. If performance is being used as a criteria, it should be based on clear, objectively drawn and well-documented performance appraisals, which have been carried out fairly and which the employee is aware of. You cannot rely upon a document which was never presented to an employee or where an employee was not made aware of constructive feedback, where they could not therefore improve. It's very important to ensure that subjective opinions in relation to performance are not taken into account. So just moving over to unacceptable selection criteria, you can see their attitude in line with company values and would keep the company viable. These are all highly subjective and therefore could place employers at risk of claims of unfair redundancy selection. The level of employee wages should also not be taken into account or considered as selection criteria. And as previously noted, it's just so important to ensure that there could be no allegations of subjectivity or personal bias. The decision to select which criteria is utilised is ultimately at the discretion of the employer. However, it must be communicated to the affected employees, and it can be helpful to give employees the opportunity to object to the inclusion of certain criteria before the selection process is carried out, because this can help prevent any later allegations of unfairness. Criteria must be objective and measurable, and it must be applied equally to all employees. And it is crucial that the same set of criteria is used to assess all employees being considered for redundancy. So once the scoring process has been completed based on the agreed criteria, the results of the scoring should form the basis of the first consultation with the employee. Next slide, please. So just a few practical points on the selection process. So firstly, who should carry out the process? And we would recommend that line managers or members of an HR department carry out this process, and at least 2 individuals should be appointed to carry out the selection to avoid any allegations of personal bias or unfairness. And it's important to be mindful of who would be in a position to hear any potential appeal. And I think, as I previously noted, it's preferably to be someone more senior within your organisation, and ensure that this person is not involved in this process. And secondly, just in the slide, is there an agreed procedure on how to carry out the selection process? So when applying your selection criteria to the pool of employees at risk of redundancy, you must do so fairly and consistently, and all scoring must be based on an objective assessment with reference to clear evidence. And the way to do that is to use a redundancy selection criteria matrix during the scoring process. So the selection criteria is entered into the matrix and applied against each employee in the redundancy pool. Employees who score the lowest would then be selected for redundancy. It is possible to attribute different scores and level of points corresponding to the importance of each selection criteria, and this is known as weighting. And this can work, for example, if, say, skills and qualifications are deemed to be very important to your business when assessing your employees. You could then attribute more points to this criteria by, for example, using a multiplier of more than 1 against this criteria to give it greater weighting. So the use of a redundancy selection criteria matrix, it does help create a transparent decision-making process, and it's a mechanism by which to fairly apply each of the selection criteria and minimise the risk of any allegations of unfairness. And as previously discussed, it's important that the criteria is applied equally to all employees in the selection pool and that the same set of criteria is used. If selection criteria is unfairly applied, a dismissal will be unfair. So it's important to bear that in mind. But thank you very much for listening. And I'm now going to pass you over to Rachel, who is going to now discuss the consultation process in greater detail.
Thank you very much, Jenny. So I now want to just touch on and look at the consultation aspect of redundancy, which is obviously very important to get right. So on this slide, I'm going to deal briefly with the basic principles of individual consultation. That's going to apply to every redundancy consultation, even if you're just, dismissing a few employees. It's very important, I think, that an employer gives as much warning as possible of redundancies while the proposals are at a formative stage. And there will be a need for individual consultation with each of the affected employees, so the employees at risk. Broadly speaking, the consultation needs to include providing adequate information to the employee at risk of redundancy, giving them adequate time in which to respond to what you're telling them, and then the employer giving full consideration to any response received back from that employee. And we would always recommend, although it's not necessary until the final dismissal meeting, that actually it's best practice that you do give your employees the right to be accompanied by a trade union rep or a fellow colleague throughout those redundancy consultation meetings prior to the dismissal one. You don't have to, but it can often be helpful if that can be offered. The employer, as part of the consultation, does need to give the employee an opportunity to comment on or to challenge the basis for their selection and the redundancy scores that have been given to them. They should also obviously ask the employee, have you any suggestions in order to avoid redundancies? And it's then on the employer to consider, are there any suitable alternative employment options that we can offer existing positions within the business to this employee? And I'll come on to suitable alternative employment a bit later on. So why is individual consultation so important? There's a very well-known case called Polkey. It's referred to a lot in redundancy case law, and it really does, it talks about a lot of things, but it emphasises that consultation with the individual employee is fundamental to the fairness of any subsequent redundancy dismissal. Now, you'll sometimes see employers' reasons for not having gone through any type of redundancy consultation, and there are quite a few sort of popular ones that unfortunately have failed. So you may get, an answer from the employer to say that consultation would have made no difference. They might say that, that employee was the only individual who could be made redundant, so we didn't see the point in going through a consultation. They might say, look, the size and administrative resources of our business means that we can't go through a redundancy procedure. Or indeed, the employer might think, well, actually, that employee will not want to be consulted, so we won't do it. But unfortunately, none of those points are going to absolve an employer of their legal obligations when it comes to redundancy. And as I'll say a bit later on, it doesn't have to be a very complicated process, but it's just important that it is done. I'm going to speak shortly about collective consultation, but always important to bear in mind that if collective consultation is going to kick into your business, then that will be on top of your individual consultation. It's not instead of, so it'll be individual and collective that you've got to be thinking about. So if you could move on, please, to the next slide, then we're going to look now a little bit at collective redundancy consultation. So, as I said, I know a lot of employers, they'll say to me, look, this seems very overwhelming and daunting and there's a lot to do here. But actually, when you break it down, it is a pretty straightforward process. But the very first question an employer is going to need to ask is, when does the business have to start collective consultation for redundancies? So that obligation to collectively consult is triggered where, and I'm reading this from the legislation, an employer is proposing to dismiss as redundant 20 or more employees at one establishment within a period of 90 days or less. So that's your sort of starting number. And it for 20 or more, so between 20 and 99 proposed dismissals, that consultation needs to take place at least 30 days before the first of the dismissals. But where you are between 100 and above proposed redundancies, then the time frame is 90 days before the first of the dismissals. Very importantly, as I'm sure everyone knows, consultation needs to be carried out before any final decisions are made and whilst proposals are still being talked about and at the formative stage. And with that, then, if there's a dismissal or if there's a decision or proposal made before the consultation ends, that's likely to render the whole process unfair. So then, with regard to consultation with appropriate representatives, we will look at this in a bit more detail on the next slide. But things to initially consider are, who are the appropriate representatives of affected employees? The answer will be to that either a trade union, where there is a recognised trade union for those affected employees, or if there's no recognised trade union, then employee representatives. And the employer might say, well, we don't have any of those. Well, then we're going to have to go through the process of elections and appointments of those appropriate representatives, which again is not as daunting a process, I think, once you get into it, as it might initially appear. In addition to that, it's very important then that if your numbers are, as I said earlier, 20 or above and 100 or above, you've got to notify the Northern Ireland Statistics and Research Agency, NISRA, acting on behalf of the Department for the Economy, about potential forthcoming redundancies on Form HR1. So the same deadlines will apply with that as when starting your collective consultation. So as I said, if there are 20 to 99 redundancies within a 90-day period, then notification has to be received by NISRA at least 30 days before the first dismissal. And where there are 100 or more redundancies within the 90-day period, then notification has to be received by NISRA within, beg your pardon, at least 90 days before the first dismissal. So collective consultation, what does that involve? It involves appointing your employee representatives if you don't have your trade union reps already set up. It involves holding your collective consultation meetings with the representatives and informing the representatives of certain specific information you've got to tell them as the employer. So, as I say, that's don't forget, that's in addition to your, your starting point of your individual consultation requirements, which is notifying about potential redundancies, giving the opportunity for employees to put forward suggestions to avoid redundancy, applying selection criteria, and considering any suitable alternative employment positions that might exist. Before I get on to collective consultation in a bit more detail, I wanted to touch briefly on voluntary redundancy. And just to remind ourselves of a few key points on that. I think some people can think that a voluntary redundancy is not a redundancy dismissal, but of course it is, because really a voluntary redundancy is where the employee is volunteering to be dismissed, but that reason for dismissal will be redundancy. So you can ask, of course you can ask for volunteers for redundancy, whether it's in a collective redundancy consultation setting or not. But if you are in the collective redundancy process, then voluntary redundancies are going to count towards the number of overall redundancies for the purposes of collective consultation. Also worth bearing in mind on voluntary that you don't have to offer voluntary redundancy. It's something that you can consider doing, but there's no obligation actually to do it. And if you decide to offer it as the employer, you don't actually have to accept the volunteers that come into you. There could be various reasons for rejection. One might be that the needs of the business require that particular person to stay in the organisation. So it's best, I would say, to consider applications for voluntary redundancy on a case-by-case basis, looking at your selection pool and lots of other factors. And, I definitely say do take legal advice on that. So next slide, please. So then here on this slide on collective consultation, you'll see the first four bubbles, which are fairness, information, content of consultation, and adequate information given over. So looking at each of these in turn, how do you as an employer ensure fairness when you're electing your representatives? So you've got to make reasonably practical, reasonably, good steps to make sure that that election process is fair. Candidates for election should be affected employees, meaning employees at risk of redundancy on the date of the election. No affected employee has to be unreasonably or should be unreasonably excluded from standing for election. And it might be reasonable to impose a minimum length of service to be eligible for election on the basis the employee on the basis an employee with a particular short period of service may not be fully aware of all the issues that would concern his or her longer serving employees. It might also be reasonable to exclude employees who are serving their notice. Now, once those representatives are elected, then they do have to be provided with certain information in writing as part of this process. They need to be told about the reasons for the proposed dismissals, now not in a huge amount of detail, but enough that will give the employees an overall picture. They need to be told about the numbers and descriptions of employees proposed to be dismissed as redundant. It's only a proposal at this stage, of course. That they're told the total number of employees of any descriptions employed at the particular establishment. They're told the proposed selection criteria and the method of carrying out the dismissals. So, your procedure and your timescales, and the proposed method of calculating any enhanced redundancy pay. That is where you do have an enhanced redundancy scheme in place, so over and above the statutory redundancy entitlement, and then certain information about agency workers. The next stage there on the slide is the content of consultation. So it has to be really with a view to reaching an agreement consultation. And it should include, as far as possible, looking at ways of avoiding dismissals, of reducing the numbers of dismissals and mitigating the consequences. And of course, proposals are still at the formative stage at this point. And importantly there in the fourth bubble, we've got adequate information. So there needs to be, if you imagine you're consulting with your representatives, they're going away and coming back with what they've been speaking to the employees about. There needs to be a genuine consideration of those responses coming back from the employees via their reps. So, you can look properly at what is coming back to you. So with all of that being said, let's say, you don't go through consultation at all, collective consultation, or you only do it partially. What are the financial penalties? So that employee can issue a claim in the employment tribunal for failure to properly consult. And if they win, got to win first, of course, the tribunal can make a protective award. Now, that is an amount up to 90 days pay for each affected employee in a collective redundancy dismissal situation. And that pay is based on gross pay. Next slide, please. Okay, next slide again, please. Thank you. So alternative employment and trial periods. I just wanted to touch briefly on these. So to what extent must the employer search for alternative employment? This is all as part of the consultation, obviously. So there's no statutory obligation on the employer to look for suitable alternative employment, although remember, there's special protection for employees on maternity, adoption or shared parental leave who do need to be offered suitable alternative employment. And actually in GB, that has recently been, fairly recently, extended to employees who are pregnant and recently returned from a period of maternity, adoption or shared parental leave. And that period of protection is 18 months from the birth or placement for adoption. So just to flag that to you. In order to go through your fair redundancy consultation process, look around and think, are there any alternative roles within the company or any group company, if applicable, which could be carried out by a potentially redundant employee? There is, and we would often get asked, do we need to go and create a new job? No, we don't. There's no obligation to create a suitable position for a redundant employee, but dismissal of an employee for redundancy could be unfair if the employer doesn't look around for, doesn't make a reasonable search for suitable alternative employment. And what should the employer consider when making an offer? So let's say employers identify some suitable alternative employment that could be offered. It needs to be made before the employee's employment under the previous contract ends. It doesn't have to be in writing, but it would be helpful if it was, and it should be reasonably precise. The contract of employment will then not come to an end if the employer offers either to renew the employee's contract of employment, which is called renewal, or to re-engage them under a new contract of employment, which is re-engagement, whether that's with the employer or an associated employer. And if accepted, then the employee will not be entitled to a redundancy payment. But if the employee unreasonably rejects an offer of suitable alternative employment, then they're going to forfeit their right to a redundancy payment. I'll come on to that in a minute. And the new employment must start no later than 4 weeks after the employee's existing employment ends. So then there's the question there on the slide, is the alternative employment suitable? And this is something employers do need to factor in. They need to look at what's the pay level of the alternative employment. It doesn't need to be the same, but what is that looking like? Looking at the job title of the alternative employment, looking at the hours, the prospect, the location and the benefits of that suitable alternative employment position. Let's say employer makes that offer and employee then refuses the offer. So you as employer are going, and this does of course happen, the employer needs to look at the reasonableness of that refusal. So they'll need to look at the manner in which the offer is made. Was there adequate time given for the employee to actually to consider that offer? What are the employer's motives or behaviour behind making the offer? What's the duration of the alternative employment? What's the employee's personal situation? The job title of the alternative role, and is there a requirement to relocate with the new alternative employment position? Now, if the alternative employment does involve a relocation, then need to look at what's the impact of relocation on family life. Is there going to be an increased time and cost of travel to the new workplace? And what is the industry in which the employee works and existing travel time? So I would say an employee should be prepared to at least consider a proposed relocation, even if they ultimately reject it, since to reject that offer of suitable alternative employment outright without even considering it could be unreasonable. And then I wanted to touch finally and briefly on this section on trial periods. So what does a trial period actually mean? So if the capacity in place where the employee is employed and the other terms and conditions of their employment differ wholly or even in part from the corresponding terms of the employee's previous employment, then the alternative employment is being offered on different terms and it's going to be subject to your statutory 4-week trial period. And the purpose of that trial period is both for the employer and employee to assess the suitability of the suitable alternative employment for the employee. Now, in deciding whether the terms of the proposed alternative employment are different from the employee's existing employee, it should be noted that all differences will count unless they're trivial or insignificant, that each employment term is considered individually. The contract isn't considered on the basis of its overall effect, and the fact that the new terms may be more favourable than the old terms is not particularly relevant. So then if your trial period is successful for the new role, that means the ending of the original contract is not a dismissal for statutory redundancy pay purposes. But if that trial period is unsuccessful, then the employee is going to be regarded as dismissed for statutory redundancy pay purposes at the date when the original contract ended. The time limit for claiming a redundancy payment from that employee runs from the date of termination of the trial period and not from the date of the dismissal. So there's some sort of idiosyncrasies there around trial periods. So next slide, please. I'm going to touch briefly on appeals. So it's important to bear in mind we are different here in Northern Ireland in several respects in employment law, quite a few actually from GB. And one is that here we still have the statutory dismissal and disciplinary procedures in place in respect of dismissals where the employee would have over 1 year's service and therefore unfair dismissal rights. So if an employer is making an employee redundant here with that required length of service, then they have to offer the right of appeal. It's different to the position in GB where the statutory DDPs no longer apply. So the appeal stage will, of course, as you know, help to resolve disputes internally without the employee having to seek recourse in the employment tribunal to begin with. And as per the slide, some reminders on appeals are, you do need to hold an appeal meeting. The appeal officer should be more senior than the dismissing officer, if that's at all possible. I know sometimes in a small business it's not, but if you can do it, you should. You will have to allow the employee to be accompanied by a trade union representative or work colleague, and you would then send the appeal outcome in writing following the meeting. And often in redundancy appeals, what we find is the reason for the appeal may be that the employee might not have been given sufficient information at the consultation stage, say about selection criteria, what was used, or information on scoring. So often you can find then that those defects or issues can be remedied at appeal. And it can be then obviously a very good way of avoiding having to deal with an ET1 when it comes in, which hopefully it won't. Next slide, please. So then just touching briefly, very briefly on redundancy pay. I'm sure as everyone here knows, the maximum amount of a week's pay and also a compensatory award for unfair dismissal purposes is slightly higher in Northern Ireland actually than in GB. So this will affect statutory redundancy pay calculations and obviously, as I said, tribunal awards. So from 6th of April 2024 in Northern Ireland, the maximum amount of a week's pay is 729 and the maximum compensatory award for an unfair dismissal claim is 115,314. Remember, these are maximums, I have to say, obviously. And the maximum statutory redundancy pay an employee can get is 21,870. But as I say, that's all subject to mitigation, and those are the maximums. Next slide, please. So what if an employer gets it wrong? I could do a whole separate seminar on this. So we've just put some very sort of good reminders here on this slide. So if the employee issues an unfair redundancy dismissal claim in Northern Ireland and they win that, they're going to be entitled to a basic award, which, as we said, is up to 21,870. They're going to be entitled to a compensatory award up to 115,314. But never forget, of course, that that employee might add on additional claims into those proceedings, such as perhaps discrimination claims. And if that's the case, then the compensation which could be awarded will be uncapped if there's a discrimination claim in there as well. And also check as well, or bear in mind that they may well claim an entitlement to an enhanced redundancy pay if you do have an enhanced redundancy pay scheme in the business. As I'm sure everyone will know, the timescales for bringing claims to the tribunal, employment tribunal, are generally, not always, but generally 3 months from the date of dismissal or the act of discrimination. But that is then going to be subject to the early conciliation rules, which of course will change those deadlines and push that window out by anywhere up to 6 weeks and even more on some occasions. So just to give you a flavour of that anyway. And then next slide, please. And then again, next slide, thanks. So I just wanted to finish here by talking about very briefly layoff and short time working. Why do employers use layoff or short time working? It's going to be as an alternative to dismissal, and usually that dismissal would be redundancy. And it'll be used where an employer might want to deal with an unexpected downturn in business or unforeseen circumstances, like production at their premises being interrupted, for example. And they might want to lay off the employees or put them on short time working. So broadly speaking, layoff of employees means the employer provides employees with no work and no pay for a particular period while keeping that employee employed, so retaining them as an employee. And short time working is providing employees with less work and less pay for a period while retaining them as employees. So unlike dismissal, which is obviously, you can't undo it, well, with great difficulty, it's a temporary solution to the problem of no or less work. An employer is going to be looking to save money where it lays people off or puts them on short time working by not paying them or paying them less for a certain period. And it usually would be in sectors such as yourselves, manufacturing, and indeed other sectors too. And it's often for types of workers such as perhaps those working on a factory floor or a piece worker, who is somebody who's paid according to the work they produce rather than the hours they work. But recent economic downturns have seen layoff and short-time working used more widely, sometimes in the professional services sector and with salaried employees. So it is something that can be called upon. I wanted to talk about what does that mean in terms of entitlement to a statutory redundancy payment. So if an employer exercises an express or implied right to lay off an employee or put them on short-time working in certain circumstances, then that employee will be entitled to claim a statutory redundancy payment. But remember that the right to lay off or put in short-time working needs to be written into the contract of employment as a term of that employment. So let's say that's in play, and let's say the employee wants to, they've satisfied those conditions, they then want to bring a claim for statutory redundancy pay. They need to have been required for at least 2 years, and they need to have been laid off or kept on short-time working for a particular period of time. And what is that required amount of time for layoff or short-time working? So the employee has to have been laid off or kept on short-time working, or actually a combination of the two, for either 4 or more consecutive weeks or a total of 6 weeks, of which not more than 3 are consecutive in any period of 13 weeks. So, as I said there, the 4 or the 6 weeks can be made up of a combination of the two, of layoff or short-time working. So just to make that point to you. So that completes the slides. We hope we find that you did find that useful. And now I hand over to Stephen, who can look at any questions that might have come up during the session, and we can address those. Thank you.
Rachel, thank you so much, and to Jenny before as well. That was a real tour de force through an enormously complex area, but delivered in a very simple, straightforward way. I mean, people need not necessarily be concerned about this if they've set themselves up properly, if they're taking good advice, and they follow the processes and follow the procedure. So I found that incredibly useful, and I'm sure others did too. A couple of questions here for you, either both or individually. Obviously, we're in a tricky moment economically. We have been for the last kind of 12 months, plus there's uncertainty ahead given political events in the United States and elsewhere. But do you expect to be seeing more redundancies in this current year given the economic climate?
I think potentially, yes, Stephen, because I think companies are under a lot of financial pressure anyway at the moment. And I think the two things that are coming up that are going to have, unfortunately, an effect on that is the national insurance contributions going up, and also pretty substantial increase in the national living wage in April. I do think that is going to have an impact on businesses for sure. And I suppose that will then potentially lead them to look at the business overall and where they can make cost-cutting measures, and redundancy, sadly, it could be one of those, the fallout from that potentially.
I think you're correct. I think certainly the reaction to the budget was almost instantaneous from our membership. People deeply concerned, specifically about the rise in national living wage. Not that there's an issue with national living wage, but the fact that manufacturing workforces have staggered salary or wage scales. So if the bottom moves, then everything else moves. So the cumulative impact there is quite extraordinary, as well as the change to employers' contributions on national insurance, as was the change in terms of inheritance tax. But that's for a different session.
Yes.
So I do agree that people are concerned what the 1st of April will look like. So we thought this was useful just to remind people of preparing themselves to protect themselves.
Yeah, I think so. And I think as well, it doesn't have to be, as I was trying to get across there, as long as you're getting, as long as you know from the outset what you're doing and that there's a genuine redundancy situation to begin with, like I think that's the most fundamental thing, because from there, then everything else flows. So, if you can get that right at the outset and you're clear in your mind as to how you're going about, are you doing collective redundancy consultation or are you not, then it can be done pretty, it is very doable. It's just there needs to be a plan, and I think planning is really important.
And obviously, no employer, no individual likes to be going through this process at either side of this challenge, whether it's the need to make redundancies, when certainly not people who may be subject to redundancy. And it's critically important that people maintain the morale in the workplace, because it's deeply unsettling for everybody involved, because they don't want to lose talent, obviously. I mean, have you seen good practice elsewhere that people have used in order to kind of try to keep spirits up and keep morale up so that they can rebuild?
Yeah, I think if they're in the middle, if the employer's in the middle or about to start a redundancy process, I think that's very important to keep morale up and to be transparent with employees, to kind of stop the rumor mill, because sometimes the rumor mill can kick off, can't it, very early on. So it's about being open and honest, and engaging with your employees, I think, at the outset of it, and keeping them informed as much as you can. Looking at having regular one-to-ones and check-ins with them, but mostly I think about having a two-way communication channel with them whenever you're going through this, because it's not of course it's not a pleasant process. But yeah, I think that's really important. Good employee engagement throughout.
And I was really struck by the effort that you both made in terms of ensuring that the proper selection criteria is in place.
Yeah. Yeah.
You can't just go, I don't like the look of that person, or
Exactly.
that person plays for
Yeah.
person played for a different football team,
Yes.
or whatever. It has to be that seems to be the critical moment.
Yeah.
Is there any kind of top tips on
That's
that
it.
kind of selection criteria?
Yeah.
I would really just say plan ahead. Just make sure you have a good plan and ensure that your selection criteria is well thought out and reasoned in order to suit your business as well, and ensure it's communicated to the affected employees, and just ultimately ensure that it's objective. That's the key point. Ensure it's subjective criteria that can be measured, that it's not discriminatory, and it can be applied in a fair and consistent and reasonable manner. So and it can definitely help to get legal advice during that process as well.
Of course.
Yeah. Yeah.
And just the last one for me, obviously, given the events of last Friday, Storm ON or YN or whatever the way you pronounce that word, obviously the advice came from our government incredibly late. We all got alerts after 5:30 on Thursday evening. That's actually raised a number of questions from employers around, well, what are our responsibilities here? What are our rights here? So is it useful that people, given the fact that we're likely to see increased storms, etc., 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 that people actually take a time to review and update their employment contracts, because they need to build in what were unknowns in the past are becoming more certain as we witness climate change and other issues. So is the good place to start the employment contract themselves?
I think so, and also the handbook, the employee handbook, and any policies that you have about unforeseen events, I suppose, and where that takes the employer and the employee in terms of what you would do in that instance. So yeah, definitely review the contract of employment, review the handbook, and absolutely, because as you say, Stephen, this could be more than, I think it will be more than a one-off event, won't it? And it probably, I think, left employers a bit in the lurch because it was announced so last minute, as you say.
It really was, and again, from past experience, I would call upon good legal support to do that process, because people may think it's easy to change employment contracts. It's certainly not.
No, it's
but
not.
It's important to keep themselves right through that process as well, I assume.
Yeah, absolutely. And there's a whole different seminar on that about changing terms and conditions. But, there absolutely are processes to go through, which ultimately results in the employee consenting to the change. So if you go ahead and just impose a change on them, that's not good. That's, so there's definitely a process to go through. And, of course, we can advise on that on a regular basis. So, yeah, absolutely.
Thank you. That's all the questions I have for now. I mean, Rachel, Jenny, obviously say thanks to you both for that excellent presentation. What's the best way for people to begin to engage if they've got concerns or issues?
Yes.
What do they do next?
Thanks for that. So on the back of the slides there's a contact sheet with our details on there. So you've got email, mobile, and you'll find us on LinkedIn as well. We're both on there. So we'd be delighted to assist anybody that contacts us. Be fantastic.
Excellent. Thank you so much to you both. Hopefully those that have watched live and later online found that useful. I can't recommend enough that people actually take the opportunity to get really good, solid legal advice. It's a tricky area, and no one wants to go through this process. So it's useful to ensure that everyone's protected as part of that process, and that begins with actually having solid advice from experts like yourselves. We will be sharing the slides. We will be sharing the recording. Hopefully people will tune in again later on. But for now, Rachel and Jenny, thank you so much for your time this morning.
Thank you. Thank you, Stephen.
Thank you,
Appreciate it.
Stephen.
Thank you. Bye.